In
Yes.
in 1990 with a BA in Political Science and History. He graduated from the Thomas M. Cooley Law School in 1993 with a Juris Doctor degree. He was admitted to the New York State Bar in 1994, the United States District Court for the District of New Jersey in 1997, and the U.S. Court of Appeals for the Third District in 2019. He is a member of the Bergen County Bar Association. Mr. Molinaro established his own firm in 1999 and represents corporations in pursuing creditors' rights issues, including debt collection and business litigation. His firm's service area includes all but the most southern counties within the state of New Jersey. His law firm is an affiliate member of the Commercial Collection Agencies of America, where he is active on the membership committee. His firm is also an associate member of the International Association of Commercial Collectors, and he is a chair of the Eastern Region of the Commercial Law League of America. Mr. Molinaro has reported decisions in Global Landfill Agreement Group versus 280 Development Corporation. And with that, let me introduce Joe Molinaro. Thank you, Joe.
Thank you, Humberto. Thank you, Annette. Thank you all for joining us today. I spoke to Annette a few months ago about possibly speaking at one of these 20-minute chats, and I agreed without even having a topic in mind. And then as I was getting ready for this meeting, I said, well, there are lots of areas that we can cover, but there's been a lot of litigation and a lot of legislation lately concerning consumer debt and exposing it, or rather, forgive me, expanding it into the commercial arena. And I thought, you know what? We're all getting bogged down with a lot of that nonsense. So I thought perhaps maybe just a discussion on some of the basics about collections and the collection practice, probably some questions that you all have and probably have lots of your clients asking of you. So I thought I'd just cover some of the basics. And that's why the program is called Back to Basics. In our practice as forwarders and as receivers, we've all seen and prepared what is typically a 4-count complaint in collections. And each of those counts in the complaint, there's 4 of them. The first typically is a breach of contract claim. Then there's another count for quantum meruit, which is a fancy Latin term for as much as he deserves. And then you'll see counts on a book account and on an account stated. And as I said, I wanted to go back to the basics a little bit, because I'm sure when you're forwarding, or rather receiving, attorneys are sending you these pleadings to be approved by your clients, many of your clients may be asking you, well, what does this mean? Well, why is this necessary? Why is this included? So hopefully this little refresher will maybe educate some of you or reinforce what you already know. And this way you can educate your clients. So we've all know what a breach of contract is, or what a breach of contract cause of action is. Parties into an agreement that needs to be enforced. The elements of a typical breach of contract action are the parties entered into a contract containing certain terms. The creditor did what they were supposed to do. The debtor did not do what the contract required them to do. And then as a result, the creditor received some type of damage. Typically, obviously, you have a situation where creditor is asked to supply 100 widgets. The debtor agrees to pay $5 per each widget. And then when the creditor forwards the widgets, the debtor does not pay. And obviously, he has damages as a result. So that's your standard and typical breach of contract action. What many clients ask, and I'm sure many of your clients ask, is, does a contract need to be in writing? And the answer is no. A contract is enforceable if it's sufficiently clear and the terms are definite to be enforced. So do you need to have a writing, or does it need to be a single writing, or could it be in a number of writings? The answer is yes. You can piece together from 20 emails, communications that form the basis of what a contract is. And that means, what is a creditor required to do? what is the debtor required to do, and what happens in the event that either one of the parties do not do what they're supposed to do. So the one exception to a contract not needing to be in writing is under the Uniform Commercial Code. Now, the Uniform Commercial Code governs contracts between people in the industry, merchants, they call them. So if you have a contract between one or two merchants, typically a wholesaler and a retailer of product, the contracts typically need to be in writing if the contract is in the amount of $500 or more. But I will tell you, and I'm sure you have seen, that most contractual agreements are for more than $500, and there are no written contract terms. And that's okay, because there are a ton of exceptions to the Uniform Commercial Code. So let's talk about the different types of contracts. Okay, sometimes you'll have a formal contract where all of the terms of the parties' understanding is expressly stated. Now, you don't normally see that in your general commercial transaction. You kind of see that in a good example of that would be when you're buying or selling your home, right? You typically hire a lawyer, or a real estate agent will prepare a lengthy form of contract, which tells, what is being sold, what's included, what the prices are, what are the terms, such as when are you going to have the closing, et cetera, et cetera, et cetera. You typically don't have that in a general commercial environment. Another form of contract, which most people don't realize that it actually is a credit application. So when a debtor comes to you and says, I want to do business with you, and you tell them, okay, well, fine, you need to sign a credit application, complete a credit application and fill it out. That is a contract, because what that credit application does is it establishes everybody's understanding as to the terms. What happens if you don't pay? Do you agree to pay interest? Do you agree to pay attorney's fees? What's going to happen in the event of a breach? So credit application is another example of a contract. Yet another example of a contract is a purchase order. So your customer, or rather the debtor, sends the creditor a contract, or rather, forgive me, a purchase order so that the creditor can build 100 cars, and he's going to agree to pay him $5,000 per car. If the creditor performs on that purchase order, you have a contract. You don't even necessarily need to write back and say, you know what, I accept your purchase order, and I'll prepare, I'll build the cars for you. All you have to do is perform. One wouldn't think this, but invoices can be a contract, and let me tell you when they can be. If you have one transaction with a debtor and you send them an invoice that has terms and conditions on it, that's not a contract, meaning that the terms and conditions that are contained on the invoice are not binding upon your purchaser. And the reason for that is typically speaking, when it's the first invoice, you don't know what those terms and conditions are because you've never seen an invoice from that creditor. But it is presumed in the law that if you have an ongoing relationship with somebody and you send them an invoice, and on the invoice it says, please see terms and conditions on our website, or please see the back of our invoice for our terms and conditions, and they purchase from you and they pay from you and then they purchase from you again, now those terms and conditions are part of your understanding with your customer. So terms and conditions are binding upon a customer, but not on the first go. You can also have, as I explained earlier, you can gather the elements of a contract from different bits and pieces. You could have several emails that are being exchanged between the parties that, when taken together, a third party like a judge can say, okay, you know what, maybe there were 30 emails talking about what they were going to do with one another, and out of all of those emails, I can fit together what was the understanding between the parties. That's the key thing. It's the court has to understand on a contract action what everybody expected of one another, and that it has to be sufficiently clear. So as I was telling Annette earlier, the section that I was going to be talking about, breach of contract, out of these 4 claims, was probably going to be the less interesting one. So I'm going to turn to what the other causes of action that are part of a 4-count collection complaint are. And I will say this, people also ask, well, why are there 4 counts? Okay. In most jurisdictions, and I would believe in all jurisdictions, you can plead different theories of liability. So you can plead breach of contract, you can plead quantum meruit, a book account, or an account stated, and all you need to do is win on one, and you're generally able to recover. So you want to maximize your chances for reasons that I'll discuss in just a few minutes. The theory of quantum meruit. Now, everybody sees that in these collection complaints, and you're saying to yourself probably, what is it with this Latin quantum meruit? It's just from old English common law. What it means is as much as he deserves. So what courts do, courts of equity will permit a recovery when there isn't a contract, when the words and actions of the parties are enough to establish an intent to agree upon contract terms. It's a equitable way of giving a recovery to a creditor so that the debtor, if there's some kind of problem with the contract, doesn't win a victory by virtue of the fact they don't have a standard contract. In order to prevail under quantum meruit, a creditor must prove that he's conferred some kind of a benefit upon the debtor, and that he conferred that benefit with some reasonable expectation that the debtor would pay for it. Nobody works for free. If that element or any of these elements are missing, then he can't recover under quantum meruit. And the third factor in quantum meruit is that the benefit was conferred under circumstances that would have put the debtor on notice that the creditor expected to be paid. Now, it's a lot of information there on quantum meruit, and hopefully it didn't go all over your head, so I'll give you a little story. And it's one that they taught us in law school. It's a situation where John Doe hires a painter to paint his house, and he's telling his neighbor, Frank, next door, at a barbecue, by the way, you may see a truck come tomorrow, as I got a painter who's coming, he's going to paint my house. So keep an eye out for him. Make sure that he knows what he's doing. Frank says, okay. Painter comes. He shows up at Frank's house. And Frank's inside, and he starts to paint the house. And instead of coming outside and saying, wait a second, you're painting the wrong house. You got to paint the house next door. Frank thinks he's going to get a bargain here. And he doesn't say anything, and he allows the painter to paint his house. Painter knocks on the door when he's done and says, okay, I'm here to collect my fee. And Frank says, well, I don't know what you're talking about. I didn't hire you to do anything. So while there hasn't been a contract, right, there's been a benefit that's been conferred upon Frank. He got his house painted. And Frank knows that the painter didn't do it out of the goodness of his heart. He expected to be paid. So in those circumstances, and that's a very, very simple analogy, that's when a court would enforce a recovery on behalf of the painter against Frank, who got his house painted. Sure, there wasn't any contract, there wasn't any discussion, but he got his house painted. He needs to pay. Turning to a book account.
I have a quick question, Joe.
Yeah, sure.
So in this scenario that you just gave, Frank is at home and he knows that his house is being painted.
Correct.
What if he wasn't at home?
That's
and he just comes home.
There's no recovery then. If he had no reason to, he didn't know that the painter was painting his house. He comes home and sees his house painted. He may feel bad. He doesn't have any duty to pay the painter. Okay. All right. Book account. Now, a book account is a detailed statement of credits and debits between a creditor and a debtor. It's an accounting or a record of credits in a book. Okay, what's a book? Well, I'm going to date myself. I'm a child of the 70s and 80s, and I used to watch on Friday night Dallas at 8 o'clock, or maybe it was 9, The Dukes of Hazzard, and I confess, I used to watch Little House on the Prairie. Now, if any of you remember that show, and maybe you won't admit it, there was a guy by the name of Mr. Olson who had a general store. And whenever somebody came in to purchase anything, Mr. Olson would go in the back room and he'd bring out this big leather volume. And he would make an entry in the volume whenever Charles Ingalls went in to buy an axe, or he needed a shovel, or he needed something, and he didn't necessarily have the cash. That's a book account. It's a record in your ordinary course of business where you maintain credits and debits. If Charles came in and said, Mr. Ingalls, I'm going to give you a chicken, give me $5 off the shovel that I just bought from you, it would be marked in the account and it would be a record. And that is what's really called a book account. And turning to the last cause of action, account stated. An account is stated, it's really rooted in common sense. If a debtor receives a statement of account, and when your creditors send statements out every single month, there is an implication and an obligation in the law that if there's something wrong with that statement, that the debtor bring it to the creditor's attention, and their silence in not addressing the statement makes it assumes in the eyes of the law that it's correct. It's just like if you get your credit card bill and you go through it and you're getting ready to write your check or send your electronic payment. If you see a charge on there that doesn't belong to you, what do? You call up the credit card company, say there's a problem here. So there's always the presumption that if you get the statement, that you're going to review it, and if you don't, you agree that it's owed. So, but all it does is it creates a presumption that the account is accurate. You can rebut that presumption by informally or formally. You can send an email to your creditor. I got the statement. This is wrong. This is not what we agreed to as far as the costs. You could send a fax. Another way that you could disprove an account stated is you could write an annotation on your check in the memo section, balance due. And I'm sure you've seen that all in your practices where a debtor tries to do that. That's also a form of an account stated. So those are the four causes of action. I just wanted to conclude my talk by saying that when your attorneys ask you for an account history, one of the reasons why they ask you for that is because they want to prove a book account. An account history shows every transaction on a customer's account from the day that they opened it until the end of the relationship. Mm-hmm. It's important because it goes through the credits and the debits and the payments, and it's a way of establishing the account. Just like an account stated, where an account statement is sent every month, if a debtor doesn't dispute it, it's presumed that it's accurate and that it's enforceable in the eyes of the law. Now, you can, like I said, you can prevail on one or multiple causes of action. You could prevail on a breach of contract, you could prevail on an account stated, and you could prevail on a book account. Quantum merit, not so, because quantum merit is a method by which a court of equity will make sure that you get paid when all other causes of action fail. So I've gone over my 20 minutes. I'm sorry. Is there any questions that anybody has about what we just talked about?
I do have a question. You had brought up attorney's fees, and I know that we've had clients ask us about attorney's fees. Mm-hmm. It's in their contract for reasonable attorney's fees. Can you talk about that and why clients are not getting every penny that they've laid out in attorney's fees?
Well, attorney's fees are contract terms, just like interest, whether it be 18%. I mean, you can't ask for 35% interest because that's, in the eyes of the law, is usurious, and the court will not enforce a usurious clause. But contract attorney's fees are a matter of common law, not common law, but they've been around for a very long time. Yes, you are entitled to recover them if they're in your credit application or if they're in your terms and conditions.
In New Jersey, will the courts give a percentage? Will they give statutory attorney's fees? What what are we looking at in New Jersey?
You always get statutory attorney's fees if the claim's in small claims. You can get contract attorney's fees, and there's some case law that goes back to the 1920s, which talk about reasonableness. I mean, the court understands that there's a commercial collection bar, and typically those cases are handled on a contingency. So courts will routinely enforce a contingent fee, even if it's a large case and the attorney only has a few hours into it. I have a few judges that haven't done that. But for the most part, even if it's what might seem as an exorbitant fee, they'll enforce it. And as I trust they'll do that in most any jurisdiction.
Umberto, you took the words right out of my mouth. I was just on the verge of asking that question about attorney's fees.
I have a question, Joe.
Yeah.
You were talking about invoices and how those, if there's multiple invoices, sorry to interrupt you in that. I apologize.
Oh, no, that's okay. Go ahead.
How that
This
can
is
be
what
viewed
it's all about.
as a contract. And so oftentimes, I mean, obviously it's different in New Jersey. I'll have files that we have, invoices, we don't have a signed contract for whatever reason. Normally it's because it was done digitally, and so they don't have it anymore in their system or something like that. So just so I'm clear, if I have whatever, 24 months of invoices and the debtor's made any kind of payment history, that means we can enforce and sue on that?
You can enforce, without a doubt, absolutely. Not only can you enforce that, because if again, you can do it under an account stated or under a book account. I mean, like I said, the law presumes that if you get a bill that's not yours, that you're going to say something about it.
Right.
So even if you don't have a formal contract, you can enforce it. And as far as the terms and conditions are concerned, sometimes a creditor will put onerous terms on the back of their invoice, and it's in very tiny print, and it has lots of provisions talking about attorney's fees, interest, and things like that. That is enforceable if on the second go. So you send an invoice, they pay it, your terms and conditions are on the invoice, they order from you again. It's assumed in the eyes of the law that you've agreed to their terms because you've seen them and you've paid on it.
Now, if you haven't paid, is it then enforceable still?
It is, because you continue to order from them.
Got it. And if it's something that, like, for instance, like rentals or something that's ongoing where you're not ordering a physical, tangible product, does that also apply?
Not necessarily, but typically if you're doing something on an ongoing basis, there's going to be an underlying contract, like on a lease or what have you.
Right. Okay. Thank you. I appreciate it.
All right. We have a question from Rhett Tallis. What about collection fees? The contract allows for collection fee, and the percentage is also stated in the agreement.
Okay, I can speak for New Jersey, and in New Jersey, collection fees are not recoverable. There aren't any statutes that provide for it, and while you can argue, well, it's a matter of contract, and the parties agreed to it. I've made the request, and I've been practicing for 30 years, 25 on my own this year, and I have never recovered collection fees. And maybe that's not the best thing to say from a networking perspective, but I have not been able to convince any judge that they are properly chargeable.
Well, it's honest. I mean, we appreciate it because it does differ from state to state. So it's good to know. And it's good for then agencies to be able to manage the expectations of their clients. When we have sessions like this, they can better counsel their clients.
Yeah, absolutely. Does anyone else have any questions? Feel free to unmute yourself. Or if you're shy like Robert Ash, just put it in the chat.
So just remember, folks, that, again, this is so that you can educate your clients, because I don't know how many attorneys forward the pleadings before they file them like we do, because we always want the client to check to make sure that we've got the right debtor, that we've got the right amount, and that we know what we're talking about. We typically send that to the clients, and they often, not too often, ask, what does this all mean? So now you have some knowledge, and you can explain to them that there's a reason behind the 4 counts.
That's great. That's, I think that has been really helpful because we do have clients that do ask us these questions all the time.
Thank you, Joe.
You're welcome. You're welcome.
Appreciate it.
Thank you all for joining me this afternoon. I hope you have a great day.
All right. Thank
All
you,
right.
everybody.
Thanks, Joe.
Thank you,
Thanks,
Joe.
Joe.
Much
Thanks, Joe.
appreciated.
Thanks, everyone.
Look at the library on the website. There's previous sessions and we'll get this one up. Joe, thank you so much. And one shameless plug, if you have not registered for the annual conference, please do so.
Oh, I have a quick question. Actually, something just came up, if anybody's still on. This is
Sure.
from Frank Carroll. If there's something different Joe would like to see from agencies that forwarded accounts, what would it be?
Oh, great question.
Nothing really that we don't talk about every single time we have a meeting. The credit application, the statement of account, a copy of a debtor's check. That is probably the most important thing that you could possibly ever give to me. Because for the most part, an account that's in collections, it's not the first time that these parties have done business with one another. And in the age of being able to go onto your bank account screen and to take the time to pull an image of a check that a debtor gave you 4 years ago, it is probably the most important thing that you can supply to us, because how many people change their bank accounts in 10 years? Not many. So
That's a good
most important.
takeaway.
Yeah.
Great
All right.
question, Frank.
All right. Awesome.
Awesome.
All right. Now, thank you, everybody. That was great. Thank you, Joe. We appreciate it. We appreciate your participation and your support. And thanks everyone for joining us for this 30-minute talk.
Thanks, folks.
Thanks,
All right.
everyone.
Thanks, everybody. Take care.
Bye-bye, everyone.